Good afternoon. My name is Marcus Gehring, and I'm the director of the Center for European Legal Studies. On behalf of the Center for European Legal Studies and the Lauterpacht Center for International Law, I welcome you all very warmly for this event, which is on such a sober occasion. The war on Ukraine, the armed attack on Ukraine, has been making the headlines for the last 10 days, and the human toll has been devastating. We are coming together today with researchers on different areas of law, trying to analyze the situation in Ukraine, the war on Ukraine. We will have very short interventions by our different speakers, and then we will have time to answer any questions that you might have in the Q&A chat. So we will come back to you as the audience in the Q&A. Our first speaker, in many ways, needs no introduction. He literally wrote the textbook, the Oxford University Handbook on the Use of Force in International Law. Professor Mark Weller holds the chair of International Law and International Constitutional Studies in the University of Cambridge. He's a former director and fellow of the Lauterpacht Center, and he served as United Nations senior mediation expert and is highly experienced in the field of international disputes. He holds doctorates in international law and international relations, in law, economic and social sciences from the University of Cambridge, Frankfurt, and Hamburg, as well as master's degrees from the Fletcher School and the University of Cambridge. And he has been, for many decades, a real authority on the use of force. And so we will turn to him for our first intervention. Welcome, Mark.
Thank you so much, Marcus, and really thank you so much for organizing this event. I think it is essential that Cambridge adds its voice in these sad days and hours. I have to apologize at the outset, though, to the people of Ukraine in particular and to the world at large, because world events tend to organize themselves in accordance with the syllabus in my course in international law. When we covered humanitarian intervention in February of 1999, Kosovo happened, and the use of force. We were studying the Security Council in Resolution 1441, when sadly the armed action against Iraq took place in 2003. When we did statehood more recently, Catalonia happened. And yes, you guessed it, 2 weeks ago, we had the use of force in my course, just as the horrible armed action, the war was launched, the aggression was launched by the Russian Federation against Ukraine. It is a really dramatic moment, much more than the other episodes to which I have referred, because this is the first time that we have had such a fundamental challenge to the prohibition of the use of force. All the other instances were somehow justified with reference to international law as we know it, be it 1441, the Security Council, be it humanitarian intervention as a proposed justification for the use of force, or self-defense, which normally is invoked in circumstances where force is used, potentially also force is used unlawfully. But here we have an episode that leads us really to ask whether we have been catapulted back to a point in human civilization that we thought we had really left behind. It used to be the case that you would ride on your glorious charger into war. You swung your saber around, did heroic deed, and came back home to be celebrated as a hero, to be bedecked with medals. And it was a great and glorious pursuit. And it really took the disasters of the 20th century, World War I, World War II, to teach us that war is no longer and can no longer be a means of national policy. And this war seems to be the first large-scale armed action since 1945 that appears on the face of it to brush aside that civilizational consensus. And that is why, in addition to the immediate suffering of the people of the Ukraine, all of us are really so tremendously shocked and worried, I think, at an even deeper level. And this concern impelled me to ask for this presentation now whether what we see here is in some way legally justifiable, or whether at least an attempt to put forward a legal justification, however controversial, contested, and ultimately unpersuasive it would be, has been put forward, or whether it really is just naked war and aggression where, as it were, the consideration for international law has been totally left out. And for that purpose, I've gone through the debates that were triggered by the previous Russian uses of force over the past 20 or so years, and looked at the Russian presentations or justifications in relation to Georgia, Abkhazia, South Ossetia, in relation to 2014, the Donbass and Crimea, and of course, more recently, the discussions in the UN Security Council and in the emergency session of the UN General Assembly to see what was actually formally argued. The previous episodes could in some way, even if there was a sense that we were talking about unlawful uses of forces, still be brought back into the ambit, into the fold of international law with some effort afterwards. They were presented, as we know from the Nicaragua case, in terms of the prohibition of the use of force, and therefore could in some way be explained consistently with some sense of international lawfulness. And here there really is the concern that it goes so far outside and beyond of what we've heard before, that there is really a challenge of a very fundamental nature we're looking at. There are 4 types of justification that have been put forward, and I'm afraid to say that they do seem to be rather alien to those of us who have looked more closely at the prohibition of the use of force and as the acceptable exceptions to the prohibition. It's the defense of the people of Donetsk and Luhansk, humanitarian intervention, the defense of the supposed states of Donetsk and Luhansk. Oddly enough, the defense of the people of Ukraine has been put forward as a justification. And finally, the defense of Russia itself. And if one looks at the structure of all of these arguments, obviously they're not really particularly persuasive. With respect to the first one, the defense of the people of Donetsk and Luhansk, yes, we had this argument before in relation to South Ossetia, Abkhazia, and then later Donetsk. Here it has been argued that the people of Donetsk were subjected to attacks for the past 8 years, the famous figure of 14,000 victims over this period, which Ukraine invokes, has also been invoked by the Russian representatives in the UN Security Council. There's the argument that the Minsk process, the attempt to have peaceful settlements and avenues of addressing this crisis, was fruitless. The argument that Kiev refused direct talks with the local authorities and therefore now it is clear, Russia argues, that there's no further possibility of peaceful settlement. But of course, the reason that the authorities in Ukraine were unwilling to have such direct talks was that there was the condition that they would have had to accept that their interlocutors would represent two sovereign states, Donetsk and Luhansk, on the territory of Ukraine, which would not have been possible, more or less. Moreover, throughout this time, of course, there were armed actions launched by the other side in the main. But Russia argues that they were now convinced that they could no longer let the people of these two regions suffer any longer, and therefore they had to intervene. And as in the previous episodes relating to Georgia and to those two territories in Crimea, there is a gleeful reproduction of the arguments put by Western states, by NATO, on the occasion of the humanitarian intervention in relation to Kosovo. In the Security Council, great play was made of this supposed parallel. But of course, that is part of the problem with many of the Russian justifications, that it takes the shape of a possible justification and applies it to circumstances that are entirely different. In relation to Kosovo, there was a genuine humanitarian emergency of vast proportions, half of the population being displaced forcibly, and the concern that the genocide from Bosnia and Herzegovina would be replayed in relation to that territory. Then we have the idea that actually this is merely a self-defense operation at the request of Luhansk and Donetsk, because you recall, these two entities, actually, they had already declared themselves states as far back as 2014. But it is, of course, only now on the very eve of the invasion that the Russian Federation suddenly recognized as states so as to be able instantly, at that very second, to conclude a defensive treaty with them and then receive a request from them for collective self-defense and use force supposedly on their behalf. So the recognition of the two territories as a state, as the outcome of the use of force, is of course unlawful. They are non-states, positively obliged not to exist by virtue of international law, and even less able to invite lawfully under Article 51 of the UN Charter self-defense. More or less, even if it was, moreover, even if it was self-defense, of course, the principle of necessity and proportionality would apply. And then we have the oddest justification put forward, which is that Russia, in fact, is, and it's really quite cynical, is defending the people of the Ukraine. They seriously argued in the UN Security Council that the Maidan, what they call Maidan coup of 2014, was unconstitutional, brought an illegal clique into office, and that the special military operation is only directed at that clique rather than the population of the Ukraine, and is kind of an operation, a pro-democratic intervention in a way, trying to save the people of Ukraine from their own citizens. And then we have this language of denazification and demilitarization that should occur in consequence. This, of course, also being justified with reference to the alleged genocide that was perpetrated against the people in eastern Ukraine, for which, again, there is no evidence. And as you know, today, an ICJ case commenced on that issue. And finally, we have a very strange rendition of the doctrine of self-defense as applied to Russia itself. It is argued that Russia announced its intention to acquire nuclear weapons at the recent Munich Security Conference, which nobody else heard about. It is, of course, Ukraine which gave up nuclear weapons it had inherited from the Soviet Union, and instead received a firm security guarantee also from the Russian Federation, which has now been so blatantly violated. There's also the argument that a NATO military presence in Ukraine would be a threat that had to be, and I quote, answered swiftly and decisively, a kind of extension beyond preemptive war into preventative war. The idea that at some stage in the future, there would be a gathering danger, which now it would be necessary to answer now while it's still easily possible. And finally, there were allegations of attacks, so-called false flag attacks the Americans warned us all about by Ukrainian forces, terrorists and saboteurs against Russia itself, which doesn't sound very credible given that at the time, Ukraine was surrounded by 200,000 armored forces surrounding Ukraine borders. But even if so, this would be in the nature of a so-called armed incident rather than a more serious armed attack, which would trigger self-defense under Article 51. And of course, necessity and proportionality would apply. The Russian representative in the General Assembly emergency session concluded that Russia is, in its special operation, I quote, exercising its right to self-defense from a regime that sought to recover access to nuclear weapons. At the same time, Ukraine pursues NATO membership and has territorial claims to Russia, I guess in relation to the Ukrainian territory of Crimea. So by activating Article 51 of the Charter, Russia not only protects itself from a nationalist threat, but also recovers validity of the goals and principles of the UN Charter and provides for full implementation of the main tasks of the United Nations, prevention of a new world war. I mean, this is the Orwellian Ministry of Truth speaking. It is a perversion of both the facts and the law, and therefore it does mean a significant stepping out of the dialogue, which in crises and conflicts we are used to as international lawyers, which is conducted within a framework of reference we would normally recognize. So quite sadly, this is a very, very serious challenge to our understanding of what world order means and what international law does to try and safeguard it. Thank you so much.
Thank you, Professor Weller. Thank you, Mark. A very sobering account of the legality of the situation. I'm now introducing a friend of the University of Cambridge, a friend of the Lauterpacht Center, Dr. Daniel Saxon, who's a distinguished fellow at the University of Leiden, where he taught for several years. Dan was also a prosecutor at the United Nations International Criminal Tribunal for the former Yugoslavia, and a senior prosecutor prosecuted war crimes in that international tribunal. More recently, he has written a book on autonomous weapons. So without further ado, Dan, you have the floor.
Well, good afternoon. And first of all, thank you very much, Marcus, for inviting me to participate in this event. It is both humbling and a bit frightening to follow Mark Weller, but I am going to do the very best that I can to address today two questions. First of all, does the ICC, the International Criminal Court, have jurisdiction to investigate and prosecute persons responsible for Russia's alleged aggression against Ukraine? And secondly, irregardless of whether the ICC has jurisdiction over the crime of aggression in this instance, can it assert its jurisdiction with respect to other serious crimes under international law? Preliminarily, for the non-international criminal law experts that are with us this afternoon, let me clarify a basic but very important point. If you look at Article 8 bis of the ICC statute, the Rome Statute, that discusses the crime of aggression, it's important to recall that there is an important difference between the crime of aggression and an act of aggression. The Rome Statute describes or defines the crime of aggression as the planning, preparation, initiation, or execution, and this is the important part, by a person in a position effectively to exercise control over or to direct the political or military action of a state, of an act of aggression, which by its character, gravity, and scale constitutes a manifest violation of the UN Charter. On the other hand, an act of aggression means the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the UN Charter. So it's important to bear in mind the difference between an act of aggression, which touches then upon state responsibility, and a crime of aggression, which invokes individual responsibilities, that is, leaders who exercise political and military control over state actions and who planned or prepared or initiated such acts. So if we're talking about state responsibility for acts of aggression, then that will implicate, for example, the International Court of Justice here in The Hague or the regional international human rights tribunals, whereas the ICC addresses individual criminal responsibility for the crime of aggression. Now, to the first question, can the ICC take jurisdiction over the persons who may be responsible for Russia's alleged aggression in this instance? The short answer, no. The ICC will not have jurisdiction. If you take a look at Article 15 bis of the Rome Statute, it says that the ICC can investigate individuals responsible for acts of aggression if they are nationals of state parties to the Rome Treaty. But in the case at hand of the Ukraine, the likely accused of the crime of aggression would be Mr. Putin and his colleagues. Russia, however, is not a state party to the Rome Statute. So jurisdiction cannot be asserted under that prong of the statute. There's one other possibility. Article 15 ter, which incorporates another jurisdictional article, 13b, says that the Security Council could refer the ongoing situation in the Ukraine, including acts of aggression, to the ICC prosecutor. But that's not likely to happen anytime soon, of course, because Russia is a permanent member of the Security Council, and such a referral would have to be unanimous. But let's not faint. Even if the ICC cannot assert jurisdiction over the crime of aggression, it may be able to assert its jurisdiction, and indeed it already has to a degree, with respect to other serious crimes under international law. On the 25th of February, the ICC prosecutor pointed out that, all right, neither Russia nor Ukraine are state parties to the Rome Statute. So therefore, they could not themselves refer this situation to the ICC. Nonetheless, if you take a look at Article 12, parenthesis 2 of the statute, states can affirm their acceptance of the ICC's jurisdiction by means of a simple declaration, which enables the court to exercise its jurisdiction over any alleged acts of the crimes enumerated in the Rome Statute, committed on that state's territory or by its nationals. And the Ukraine has twice exercised its prerogative to legally accept the court's jurisdiction over alleged crimes under the Rome Statute occurring on its territory. The first such declaration was submitted in 2014, addressing events between 21st of November 2013 and 22 February 2014, the period of time when Russia annexed the Crimea. Secondly, they submitted another declaration that extended the time period on an open-ended basis to encompass ongoing alleged crimes committed throughout the territory of the Ukraine from the 20th of February 2014 onwards. And that led the ICC prosecutor to initiate a preliminary investigation. And last week, the ICC prosecutor said, yes, we are now convinced that reasonable grounds exist to suggest that crimes falling within the jurisdiction of the court have been committed within the Ukraine. Yeah. Subsequently, 38 states, alphabetically starting with Albania, from all over the world, Colombia, Costa Rica, from South America, states in Europe, Norway, the UK, France, Spain, submitted a referral of the situation in the Ukraine to the ICC prosecutor. And indeed, a trial chamber, a pre-trial chamber of the ICC has already taken care of the situation. But now I need to put my prosecutor's hat on and sort of urge a bit of caution amongst the non-prosecutors who are watching this program today. There is a huge gap between an assertion of jurisdiction by a court or by a prosecutor's office and the actual prosecution of persons allegedly responsible for such crimes. For example, the ICC prosecutor might investigate war crimes contained and enumerated in Article 8 of the statute, violations of the laws or customs of war applicable in armed conflict, especially when committed as part of a plan or a policy. In the case of the ongoing events in the Ukraine, that could include, for example, intentionally directing attacks against the civilian population and or civilian objects. And indeed, that would include the use of indiscriminate weapons, because if a military commander launches indiscriminate weapons, particularly in an urban area, weapons that cannot be easily targeted, that would indicate intentionality to harm civilians. And you may want to check out the Human Rights Watch website, because last week they reported on Russia's use of cluster munitions in urban areas of the Ukraine. And cluster weapons, not only are they banned under an international treaty, they are notoriously indiscriminate. Okay. Another possible crime, intentionally launching disproportionate attacks which could be anticipated to cause civilian injuries or damage to civilian objects that is clearly excessive to an anticipated military advantage. Yeah. Now we have an armed conflict. There's no doubt about that at this time. But the challenge in proving war crimes will be proving intent on the part of the military commanders from the lowest to the highest levels. Losses of civilian life, destruction of civilian property, as we've seen on the news for the past week or so, they are terrible, they are tragic, but they may not be crimes. And so we simply have to bear that in mind. Similarly, the court could take jurisdiction over crimes against humanity. Widespread or systematic attacks directed against a civilian population with knowledge by the perpetrator of this attack. Murder, extermination, torture, forcible transfer, imprisonment. The challenge in this case will be for ICC investigators and prosecutors to prove the existence of an attack against a civilian population, because the ICC statute specifically says that such an attack against a civilian population must be pursuant to or in furtherance of a state or organizational policy to commit such an attack. Clearly, I'm not an expert on the Ukraine or on the ongoing events there, but I can simply say that based on my own experience, watching the limited amount of media that I have in the past few days, the media reports, as gruesome as they are, they do not necessarily demonstrate the existence of a policy by the Russian state to attack civilians in the Ukraine. So it's proving the existence of crimes against humanity, and even more difficult, proving someone's individual criminal responsibility for such crimes. It's going to be very challenging. So I'll stop there. Thanks.
Thank you very much, Dan. Again, quite sobering. Our next speaker is Francisco Jose Quintana, who's a PhD researcher at the University of Cambridge. He holds LLMs from the LSE and Harvard Law School, and has been working as a lawyer in his native Argentina. He's a specialist on human rights, and so Francisco Jose, how do you evaluate the current legal situation in Ukraine?
Thank you very much, Marcus, for putting this event together, and to everyone at the Lauterpacht Center and the Center for European Legal Studies for making it possible. I was talking with a colleague last week, and we discussed the invasion, and I asked him whether he was planning to make any kind of intervention, say writing something for the media. He said he wasn't, and explained that the atmosphere seemed too noisy. And I think he's right. I think that so many terrible things are happening every day, and a lot of international lawyers are intervening professionally and academically. I think this underlines the importance of this comprehensive conversation we're having today. And I am humbled to talk after these two extraordinarily illuminating interventions. And it is also one of the reasons why I want to use my few minutes to engage in an exercise of mapping. So specifically, I want to map a few central ways in which human rights have been involved or employed in and around the world. As a caveat, these are far from exhaustive, but I do think mapping is particularly important in the context of human rights. Human rights have become the closest to a universal moral language in the world, and critics have long argued that human rights occupy too much space. I think legal analysis is a particularly valuable tool to understand what claims can be made in the language of human rights, what specific possibilities they have offered to resist or advance hegemonic interests, and thus illuminate the possibilities and limits they might offer to denounce and resist abuses in our present disturbing context and beyond. So I will identify and put on the table very succinctly, yes, 6 broad human rights aspects in this world. First, an uncomfortable starting point is to note that human rights have been cynically invoked by Putin, by Russia, to justify the invasion. So the justifications were absurd. There is no plausible legal or any other justification for this aggression, as Professor Waller has explained so clearly. But I do think that the fact that Putin chose to specifically mention earlier arguable violations of the prohibition on the use of force, so he mentioned Kosovo, Libya, Iraq, Syria, some of which were justified by reference to human rights and humanitarian considerations, I think that's significant. So Putin complemented this critique of prior violations with the notoriously false claim of intervening to stop a genocide of Russians in eastern Ukraine, to craft something resembling or one of Russia's justifications. All of this has given rise to important debates. So Ingrid Wirth has provocatively argued that states should reinvest in norms of territorial integrity and sovereignty, even at the expense of human rights. And Nico Krish has responded that human rights and humanitarian considerations should not be excluded from the development of a stable new regime on the use of force, but that they should be properly delimited. So a central takeaway from this starting point, I think, is the reminder that illegal acts can give pretext for further illegal acts, and that the concern for human rights can but should not make us forget this. A second peculiar way in which human rights have been involved is in adjudicatory proceedings at the International Court of Justice, as has been mentioned already as well. So several cases claiming violations of the use of force have been brought before the ICJ, entailing the possibility of declaring that the state has acted in breach of the prohibition of the use of force, as well as declaring provisional measures and eventually awarding reparations. Now, as is well known, Russia has not accepted the ICJ's compulsory jurisdiction. So Ukraine has filed an application and a provisional measures request against Russia, but it has grounded the court's jurisdiction in the Genocide Convention, focusing not in the commission of any genocide, but on the false claim of genocide made by Russia. At the same time, and significantly, there is already a pending case between Ukraine and Russia at the ICJ. With regard to the situation in Crimea, Ukraine's claims are based upon the International Convention on the elimination of all forms of racial discrimination. So the ICJ will be addressing the Russian military interventions in Ukraine to a large extent by reference to human rights norms. One third aspect concerns human rights and international justice. So Frederick Magret has asked what international justice for Ukraine might look like in this context. An obvious response could be and has been to resort to international criminal law, certainly against the sad background of several allegations of war crimes. Several important developments have taken place in this direction. Some just explored very helpfully by Dr. Saxon. It is now a well-established critique of international criminal courts that they might divert attention from collective and structural causalities and responsibilities, that international criminal law might not be enough. Now, human rights are often criticized as well for constructing problems and solutions too narrowly. However, in this context, I particularly appreciate Megret's argument in a somewhat opposite direction. Considering the jurisdictional limitations of the ICJ, Magret has emphasized that the European Court of Human Rights and the Human Rights Committee could be important forums to hold the Russian state responsible via interstate proceedings, which might come closer to a more comprehensive idea of justice than individual criminal responsibility. Let me turn to a few notes on the UN human rights system and the right to life as my fourth aspect. So the Office of the UN High Commissioner for Human Rights has said that over 1,000 civilians casualties in Ukraine have been verified, including hundreds of deaths. In a resolution adopted on Friday, the UN Human Rights Council has agreed to establish a commission to investigate violations. At the same time, Russia and Ukraine are state parties to the ICCPR, and both have recognized the competence of the Human Rights Committee to receive and consider communications submitted by another state party and by individuals. Now, of course, this entails a complicated question about the applicability of human rights in armed conflicts. The mainstream position, as is well known, endorsed by the ICJ, is the co-applicability thesis between international humanitarian law and international human rights law. That substantive tensions remain between the two bodies of law. And as is well known, in most ways, international humanitarian law is more permissive. Now, Ukraine and human rights victims might find the Human Rights Committee particularly helpful, and this is because the committee, in its general comment 36 on Article 6 of the ICCPR on the right to life, is very clear. So the committee argued that states parties engage in acts of aggression as defined in international law, resulting in deprivations of life, violate ipso facto Article 6 of the Covenant. And as we know, the General Assembly has overwhelmingly condemned Russia's invasion as an aggression. Fifth point, the European Court of Human Rights. Ukraine and Russia are also parties to the European Convention. Last Monday, Ukraine requested and the court issued interim measures. While the court's order is not available, as usual, the press release explains that the court decided to indicate to the government of Russia to refrain from military attacks against civilian and civilian objects. And the court cited a real and continuing risk of serious violations of rights, including the right to life and the prohibition of torture. Now, the question about the applicability of the European Convention in armed conflict is particularly complicated. This is because of the several disputes concerning Article 1 and the extraterritorial application of the Convention. It suffices to mention for my mapping purposes that the key decision here is last year's Georgia v. Russia decision dealing with the 2008 conflict between both states. The court found Russia responsible for serious human rights abuses after the conflict, but refused to look at any of the alleged substantive violations of the right to life during the active hostilities. The crucial argument was that the chaos of the hostilities prevents states from exercising jurisdiction in the terms of Article 1. Thus, in accordance with last year's decision, the convention would not apply to the current conflict, but things would be different in territory under occupation. At the same time, last week's interim measure seemed to presuppose that the convention does apply to the active phase of hostilities and protect civilians. So there is a clear tension here to follow in the next time. So now for my final point, very briefly, a note on sanctions against Russia. Sanctions have been center stage since the invasion. Sanctions must respect human rights. Last year, the special rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights submitted a comprehensive report. She argued that a preliminary and continuous assessment of the humanitarian impact must be conducted under the precautionary approach, even if measures are taken legally. No good intentions can justify human suffering and the violation of fundamental human rights as collateral damage. The UN High Commissioner for Human Rights has added that there is a place for asset bans, visa restrictions, and other punitive measures against individuals, but the sanctions which target whole countries or sectors of economic activity should be avoided. All these interventions, of course, predate the war, which has made everything incredibly more complicated and has shocked all of us. But as general as they are, they remain relevant. I think I have run out of time, so that's enough for now, and I look forward to the Q&A. Thank you very much.
Thank you very much. That was very clear and again, quite sobering. Our next speaker is Professor Marie-Claire Cordonnier-Seger. She's the Senior Director of the Center for International Sustainable Development Law and the Leverhulme Trust Visiting Professor at the University of Cambridge's Bennett Institute for Public Policy. She's also a fellow of the Lauterpacht Center and a fellow at Lucy Cavendish College. Welcome, Marie-Claire.
Thank you very much, Marcus, and thank you to CELS and to the Lauterpacht Center as our rapidly reacting hosts. Also to the students and others who are showing their interest by joining us online, and especially, of course, to Dan and Mark and Francisco Jose, who have so clearly illuminated some of the most pressing legal challenges in this instance. Russia's invasion of Ukraine impacts and is impacted by public international law in many respects, as you have outlined. I think my only piece of the puzzle to add here is that at the intersection of law and public policy, the Russian invasion also has important impacts on people's livelihoods and economies, especially obviously in Ukraine, as well as on the environment that we all depend on in Europe and worldwide. Ukraine and Russia both adopted the 17 Global Sustainable Development Goals, and both are parties to many binding treaties and covenants of great relevance to advancing the 169 targets of these SDGs. Priorities to 2030 include SDG 1 and 2 on ending poverty and zero hunger, SDGs 3 and 4 on health and education, SDG 6 and 7 on access to water and sanitation and to clean energy, and also SDG 9 and 11 on innovation, industry, and infrastructure, as well as sustainable cities and communities, or SDG 13 and 15 on climate action and the protection of life on land, as well as SDG 16, peace, justice, and strong institutions. Progress on these sustainable development goals, among others, and implementation and compliance with the related treaties which Russia and Ukraine have signed, especially for Ukraine, is dealt a terrible blow by the invasion. Not only are there many sustainable development treaties in which implementation is now prevented, indeed set back by decades by the impacts of the armed attack, but indeed Ukraine's recent efforts, with which we and others have been working quite closely to promote a greener economy and to set in place sustainable infrastructure with significant investments, both in terms of grants and projects supported, for instance, by the Green Climate Fund or other climate finance mechanisms, as well as grants and loans provided by the EBRD and other international financial institutions, is rendered lost, and the price will be paid by the future generations of this country and indeed all across Europe. So this is not my area of expertise. I especially appreciate Dan's very wise cautions about international criminal law, but it is clear that conflict takes a terrible toll on all three pillars of sustainable development: people's human rights, their economies, and the environment itself. The decision to encircle Chernobyl and other nuclear power plants, for instance, placing these dangerous facilities and their containment fields for radioactivity at risk, is one that it is to be hoped the ICC prosecutor will carefully consider in the ongoing investigations. I would probably be remiss not to add to Dan's very brief intervention that he was given time for by simply noting that widespread long-term and severe damage to the non-human environment is clearly, if excessive in relation to the concrete and direct overall military advantage anticipated, an important consideration in this respect. So I will stop there with just a brief plea that if we care about all of the work that has been done under the United Nations to end poverty and to secure less hunger in the world, all of the obligations that we have through the World Health Organization, through the UN Convention on the Rights of the Child, on health and education, all the commitments that we've made in terms of securing access to water and sanitation, not the least as defined by the ICESCR, the International Covenant on Economic, Social, and Cultural Rights, and indeed by the Energy Charter Treaty and the various renewable energy and energy agencies, as well as the investments and grants and loans that have been offered for infrastructure and for more sustainable cities and communities, not least the Paris Agreement and the United Nations Convention, Framework Convention on Climate Change, on climate action, and the various biodiversity related treaties. If we care about any of those commitments that have been made over the last 50, 3/4 of a century, we should be equally doing everything we can to assist with the crisis that is building on our borders. Thank you.
Thank you very much, Marie-Claire. And our next speaker is Dr. Emilia Nenate. She's the co-deputy director of the Center for European Legal Studies. She's also a fellow of the Lauterpacht Center for International Law, and will be analyzing the situation from a point of view of European Union law. Emilia, you have the floor.
Thank you very much, Marcus, and thank you very much for organizing this discussion today. Now, we've seen a wave of responses, obviously, to the invasion of Ukraine, and alongside this wave of responses, we've also seen questions of whether these responses are adequate and what the responses should be. Now, my aim is a very modest one. I would just like to provide some basics of the relationship between the Ukraine and the EU. Now, this relationship is based on the 2014 association agreement between EU and Ukraine, which has replaced the 1994 EU-Ukraine Partnership and Cooperation Agreement. Negotiations of the association agreement started in 2007, and it entered into force a decade later in 2017. Though provisionally, trade chapters were applied since 2016. and political chapters since 2014. It's a mixed treaty. That means that it has been signed both by the EU and member states, and it had to be ratified domestically by the national parliaments. Now, this national approval did not go without obstacles. The Dutch public rejected the ratification of the association agreement in a non-binding referendum. Now, this Dutch problem was solved through a 2016 decision of heads of state of all EU member states, which was annexed to the European Council conclusions. And I will come back to this 2016 decision in a moment. Now, just to give a very brief overview of the association agreement, it is made of two main blocks, the political chapters and trade chapters. And the trade chapters constitute the deep and comprehensive free trade area. So we have this framework agreement with a free trade area in it, something that we see similar in other treaties like the Trade and Cooperation Agreement between the EU and UK. Now, in terms of the trade chapters, there's a commitment for gradual reduction or elimination of customs tariffs according to the schedule. EU is Ukraine's largest trading partner since 2016, when these trade chapters have become provisionally applied. The exports from Ukraine to the EU increased by 48%. So this agreement clearly is an important one to Ukraine. Now, significantly, the Ukraine has made a commitment to gradually align, regulatory align its legislation with the EU in various areas, technical barriers to trade, sanitary and phytosanitary, competition, IP, and so on. So there's a regulatory alignment with EU rules. And importantly, there's also jurisdiction of the European Court of Justice if disputes raise questions of EU law. Now, in terms of mobility of persons, there's obviously no free movement of persons, but there's a visa-free regime for short stays. Now, speaking about these political chapters, now it's all phrased in the language of political dialogue. Article 4 lists the aims of political dialogue, and we see there a commitment to promote gradual convergence on foreign and security matters with the aim of Ukraine's ever deeper involvement in the European security area. Right, and among these aims, there's a commitment to deepen cooperation in the field of security and defense, and a commitment to promote principles of independence, sovereignty, territorial integrity, and inviolability of borders. And actually, these last phrases are very often used by the European Commission in its communications regarding the Ukrainian invasion. So we see that language in the communications from the Commission. Now, Article 10 of the Association Agreement talks about military technological cooperation. It says that parties shall explore the potential of military technological cooperation. Now, here is where the 2016 decision, which resulted from the rejection by the Dutch public of the association agreement, this decision is relevant here. It says that the association agreement entails no obligation to provide collective security guarantees or other military aid or assistance, right? Now, this can be compared or contrasted with the UK-Ukraine agreement, which was signed in 2020, right? Because the UK post-Brexit is no longer part of the association agreement with the EU, so they negotiated their own separate agreement. Now, the UK agreement with Ukraine uses a different language. It's generally modeled on the EU association agreement, but many aspects are different. And Article 9 says, parties shall effect military and military technical cooperation. So there seems to be a stronger commitment in that sense. Overall, the UK agreement seems to use a much more direct language towards Russia. In fact, the agreement between UK and Ukraine refers to the quote, Russia's hostile actions and attempted annexation of Crimea and Sevastopol 10 times in the agreement, something we do not see in the EU-Ukraine Association Agreement. Now, a final point on the question of membership. The association agreement itself does not contain a commitment for the EU to grant a candidate status to Ukraine. And in fact, again, referring back to the 2016 decision, which again followed this Dutch rejection, Dutch referendum, which rejected the ratification of association agreement, it says as well that the association agreement does not confer on Ukraine the status of a candidate country for accession to the Union, nor does it constitute commitment to confer such status in the future. We do have the resolution of 28th of February by the European Parliament on the Russian aggression against Ukraine, which addresses the question of membership of Ukraine in the EU, and it calls for EU institutions to work towards granting EU candidate status to Ukraine. But 2 points are important here. It says that such granting must be made in line with Article 49 and on the basis of merits, which seems to rule out sidestepping of accession procedure and granting automatically such membership. But of course, this question is probably still going to be addressed in the coming weeks. So this is my brief overview, and thank you very much. Looking forward to the Q&A. Thank you.
Thank you very much, Dr. Linates. Thank you, Emilia. I had prepared a short intervention on, as convener of the EU External Relations course, the course on EU and international law here at the Faculty of Law. I was reflecting on the significant innovations with regards to the sanctions that the EU has imposed. These are unprecedented sanctions. They have moved really from just financial sanctions of a list of people to sanctions of television channels, overflight rights, which the EU as a whole had never granted, and the delivery of weapons to Ukraine as a party under the EU agreements. I should highlight that similar to Article 5 of NATO, there is provision in the EU treaty to defend any EU country and assist any EU country that suffers from an armed attack and has the right to self-defense under Article 51. So while countries like Finland and Sweden are neutral, they are enjoying a certain level of European defense protection under the EU treaties. I also wanted to briefly highlight the unprecedented level of temporary protection that the EU grants refugees from Ukraine. The Temporary Protection Directive of 2001 was invoked by a decision of the Council, which established that the preconditions of the Temporary Protection Directive are fulfilled, that for 3 years, Ukrainian nationals and those permanently resident in Ukraine who can't go back to their own country or stateless have the right to reside, to work, to access benefits in the EU member states. And they can, there is a sort of solidarity clause So with the consent of the refugees can be settled in other EU countries. All of this has never been used before. In a way, the war, the armed attack on Ukraine has really united European countries in ways and levels that have been unprecedented. And this could easily lead to a kind of constitutional change of the European Union that we've not seen before, whereas, for example, the move towards a European defense, maybe even a European army, could be accelerated in the process. I wanted to keep my own intervention very short. We have excellent questions from the audience that I would like to pick up. If you have any questions and you're listening to our presentation, please post your question in the Q&A under the Q&A button. The first question comes from our visiting fellow at the Lauterpacht Center, Tove Wolf-Nielsen. He says, my question goes directly to the crime of aggression. As the international crime was quite recently implemented in the Rome Statute. Ukraine is not a state party to the Rome Statute, but has legally accepted the court's jurisdictions over alleged crime, and also implemented the crime into domestic law. In addition, permits trials in absentia. Now, Tove, I'm not sure, but this strikes me as a question that goes to Dan. And let me add to this, Dan. The crime of aggression is a crime in about 38 countries around the world. Now, prosecuting a head of state and a foreign minister might be quite difficult. But if you could also say something about the problem of immunity before national tribunals, including the criminal courts of Ukraine.
Okay, I think those are several questions packaged into one. Each one of them could probably be the subject of a PhD thesis, but I'm going to do my best. In terms of the immunity of state officials within national jurisdictions, that I think that is going to depend in part, obviously, upon the black letter law of the domestic jurisdiction itself. If I'm not familiar with the case law or the positive law of Ukraine on the issue of universal jurisdiction, but if it is broadly written, then I don't think it would permit the immunity of someone based on their particular government position at the time the act occurred. With respect to Tove's question, I'm not exactly sure what the question is. What I'm reading is Ukraine is not a state party to the ICC statute, but has legally accepted the court's jurisdiction over alleged crimes under the Rome Statute. And also, I'm not quite sure what the question from Tove is. I'm not quite sure what I'm missing here, or should I be actually reading?
And I think the question was posed right at the beginning of your talk, and I think your intervention already answered part of Tove's question, if I interpret his question correctly. Unfortunately, we can't bring him in and ask him. but maybe he can post a clarification in.
I think I see, because actually he wrote, I believe he wrote two separate bits of thread here, and it is my understanding that only state parties, that the crime of that the ICC can assert jurisdiction, as I read Article 15, only when it, the problem is Russia. The problem is that the likely accused or suspects in this matter, suspects of responsibility for the crime of aggression, are Russian nationals. Russia has not accepted, Russia is not a state party to the ICC statute. It has not submitted any declarations pursuant to Article 12.2 accepting limited or broad jurisdiction of the ICC. And so therefore, assuming jurisdiction over investigation of Russian perpetrators of the crime of aggression, I think would be outside the court's jurisdiction at this time.
Thank you very much. We have two questions that I'd like to sort of block together. One, no, maybe the next question by Cesar Villegas on, do you think the resolution by the General Assembly of March 1st constitutes an ultra-virus action of the General Assembly? Is it consistent with the UN Charter? Let's go to the expert on the UN Charter, Professor Weller.
Thank you very much. No, it is definitely not ultra-virus. The UN Charter as drafted provides that the General Assembly should not make a recommendation in relation to issues under consideration by the Security Council. I think that's where the question comes from. But the practice of the UN General Assembly over the last 60 years has been to engage very actively in parallel with the Security Council in recommendations and adopting resolutions. In addition, here we have the fact that, of course, the resolution was adopted by an emergency special session of the General Assembly in application of Resolution 377A, Uniting for Peace, which provides for a referral by the Security Council of a matter to the General Assembly where the Security Council is prevented due to the application of a veto from exercising its functions relating to international peace and security. So I think provided that the Assembly resolution does not intrude upon the Security Council's authority established under the Charter of actually taking decisions, like say authorizing the use of force, there is no legal problem here. Instead, the General Assembly has confirmed the legal identification of the facts. In this case, an act of aggression has occurred. That's actually the title of the resolution. And then in a number of paragraphs, it outlines what the consequences at a minimum of this act of aggression must be: cessation of violence, withdrawal of forces, compliance with humanitarian law, removal of the purported recognition of the two entities as states, and so forth. So in that way, the UN General Assembly confirms obligations that are already available in general international law that flow automatically. So it is not possible to argue that the General Assembly has exceeded its authority in confirming what is already there, and it has not violated the terms of the UN Charter, both with reference to 377A and 60 or more years of practice of General Assembly activity.
Thank you very much, Mark. If I could also give you the next question by John Boddy, who asked, who's a participant in the international relations program, and asked whether there shouldn't be a kind of, if Russia is a party to a dispute, must Russia abstain from a vote under Chapter 7 or Chapter 6? He says he's not familiar with the true effects of this, but his question is, will this have any practical effect on the standard Security Council resolution vote, i.e. is the forced abstention applicable to a Security Council resolution that would condemn the Russian Federation's action or authorize any other action?
Just as I noted a moment ago, the practice of the United Nations has advanced in some instances a little bit beyond the wording of the Charter. In this instance, sadly, no, states have not complied with the idea that they should abstain if their own dispute is under consideration by the Council. This arose, for instance, in relation to Libya and the Lockerbie issue and a number of others. And there's also the fine distinction between a dispute and a situation in relation to Security Council action. But in principle, sadly, just like Article 12 on the General Assembly should not act in parallel with the Council, here Article 27 on voting and other provisions have actually in practice not been implemented. And we saw that the veto was, of course, treated as being operational when a Security Council resolution was proposed in the Council on the Ukraine. It was rejected due to the veto of Russia. Otherwise, it had the necessary majority and no other permanent member voted against, China abstaining.
Yeah, Mark, another question from me. You've also written a book on peace treaties. How could this terrible situation end? Will there be decades of reparation payments from Russia to Ukraine after this is all over?
Well, that is really too early to say, and sadly a cheeky question from you, in the sense that it really depends, unfortunately, I think, on the outcome on the battlefield. At the moment, there seems to be a sense on the part of the Ukrainian government that they are doing better than many have expected, that they can actually foresee winning. On the other hand, I can't see Mr. Putin foreseeing that he might lose. There's a very personal association between him and this war, and losing it formally would, I think, be very difficult for his political future, which I'm sure he will wish to safeguard. There are attempts underway to think about the so-called off-ramp. How can a face-saving way be generated that would allow the parties to retreat from their positions? But that will be also not only, well, we could conceive of ways in which Russia could perhaps have a face-saving way to step backwards, but it will be very difficult to persuade the Ukrainians that any concessions ought to be made unless they are faced with a situation of further overwhelming loss of human life to no end, as it were, that they are put in a position that further defense seems to be entirely hopeless. And the question arises, are we going to risk more thousands of lives for no purpose? But yes, people are thinking about the so-called off-ramp, but it's very difficult to give one clear answer as to what that would be unless we know a little bit more about the outcome of the conflict. And that is the tragedy of the situation, that it is not reason, not law that seems to decide the outcome, but it seems to be at present the force of arms, and the force of arms applied indiscriminately and unlawfully.
Yeah, very sobering. I'm looking to the other panel members. Francisco Jose, there's a question on whether there's any impact of the current ICJ case or then the provisional measures that could directly impact on perhaps the Security Council or any the war itself. Did you perhaps want to take that supplementary question, Francisco?
Thank you, Marcus. I don't quite get, I think, isn't that question, I think it's a following question to Professor Weller, isn't it? I mean, I'd love to speak more, but I'm actually learning from Professor Weller on this, so I'm happy if he was.
Okay, maybe we then hand back to Mark. Professor Weller, provisional measures before the ICJ, will they stop the war?
No, they will not stop the war, sadly. We've had some previous occasions where an attempt was made to involve the ICJ in seeking to end genocide. As we heard earlier, I think this case is somewhat odd in as much as Ukraine seeks a declaration that there was no genocide, as opposed to the Bosnian genocide case, where Bosnia and also Croatia in another case sought a declaration that genocide had occurred or was occurring. Here, the argument is that Russia has invoked an alleged genocide in the two oblasts as one of its justification for the use of force. So the court is being asked to rule that that is actually not true, that no genocide has occurred. And therefore then it would be a means of attacking, as it were, the justification, the false justification for the use of force in this instance. My fear is that even if that succeeds, that cunning scheme, as it were, that Mr. Putin will not be greatly impressed. As you know, the Russians have not even appeared before the court. Their bench, as it were, was empty this morning when the initial hearing on provisional measures was conducted at The Hague.
Yes, Francisco, did you want to come in?
Marcus, I was just reading one of the questions from the Q&A and didn't quite get that this was a question. So of course, I mean, I agree with Professor Weller that provisionary measures won't end the war, but it's also a relevant consideration. I mean, the politics of international armed conflicts and what and the implications that present for the rationale of international courts and tribunals, and that actually relates to the point that I was discussing in my presentation about extraterritoriality and the European Court. I mean, the arguments are getting more and more complicated, and the only way one can just make sense of it is that, and one can even empathize with the court, or at least sympathize with what it takes as an incredible threat to its political power and its ability to operate. People are expecting and asking too much of international tribunals, much more than they can really do. I think for the European Court, that's a much more existential question than for the ICJ right now.
Yes, very sobering. I've got a question for Marie-Claire and for Amelia as well. Marie-Claire, as someone who works on climate change, what do you think fossil fuels have to do with the current conflict?
Well, actually, I think the easiest way to answer that is simply to echo some comments that were made in a seminar on that issue earlier today here in the University of Cambridge, where somewhat optimistically the participants concluded, together with Nigel Topping, who serves as the UNFCCC sort of champion on these issues, that if there ever was an opportunity to end dependency on fossil fuel and natural gas, this would be the right time to be trying to do it. And that indeed, if we wanted to look at the investments that we are making, and if we wanted to look at the rising fuel prices for natural gas and oil here in Europe, we would find many imperatives for making the shift that we have committed in the Paris Agreement and that we have restated with great vigor just recently here in the UK as we hosted COP26. Might be a good idea to move forward on those commitments just as promised and equally fast right now.
Yes, thank you, Marie-Claire. And I've got another question as the chair. Emilia, you are from one of the Baltic states, and we know that the Baltic states have borders with Belarus and Russia. Can you share what the perception is in that part of the European Union on the conflict in Ukraine?
I think that Lithuania is and all the Baltic states, we are in a rather difficult situation, not only since the beginning of this invasion in Ukraine, but we have been now for almost a year, I would say, tackling a hybrid war, which we say that Belarus has instigated for us. So we are in this difficult situation, sort of trying to survive in this hybrid war for a while now. In terms of Lithuania itself, first of all, we are hugely supporting Ukraine in this war. And in fact, Lithuania was the first country which ratified the association agreement with Ukraine. We are supporting and we are also supporting the Ukraine's candidacy status in the EU. But for ourselves, of course, we have our own fears of our situation. I believe, if I'm not mistaken, that NATO has recently shifted from mode of from mode of deterrence to mode of defense, meaning it stepped up their status in the Baltics and Lithuania. So very, very sensitive situation, I think, at the moment.
Yeah, I can only add that we've also seen fundamental policy shifts in Germany by the so-called traffic light coalition partners, which is in direct response to an aggressive war here unleashed on Ukraine in this situation. There's one question that Joel Nikchich asked about the UK rapid deployment teams that support consular operations in UK embassies, for example, in Poland, Hungary, Slovakia, Romania, and Moldova. They will support British nationals who've crossed Ukraine's border into these countries. What about African who are facing racism? And this is, so the UK, I would argue, has been less generous in terms of immigration rules than the EU countries. Even Ireland has waived the visa status for Ukrainians, so they can enter Ireland and then benefit from the temporary protection directive in all countries except Denmark. Denmark doesn't participate in that system. But neither does the UK as a former EU member state. We've seen over the weekend the low numbers of visas granted. 16,000 people have applied for temporary visas, and only about 50 or a few more have been granted. So the UK has been, in my view, less generous when responding to the refugee crisis that was triggered by this aggressive war. Of course, the reports of racism at the border are completely unacceptable, neither under EU law nor under the national law of the member states. Can you distinguish refugees on the basis of their skin color? That is, those kind of reports are worrisome. They need to be investigated, and maybe there could be assistance by Frontex, by some of the EU mechanisms that exist for refugees and for border control in this field. I know the African Union has issued a statement really criticizing these kind of incidents, which from the EU's perspective don't comply with either the temporary protection directive or the implementation of general border policy of the European Union. I'm afraid that is unfortunately all we have time for. Are there any last interventions from my fellow panelists this afternoon? No, then as director of CELS and fellow of the Lauterpacht Center, I thank you again for your contributions this afternoon, greatly illuminating the difficult legal terrain that this terrible war in Ukraine triggers. In many ways, the students who participated in the seminar and the two research centers are very grateful for your contribution. And we're also happy that this video and the seminar itself will be available on the two research centers' websites in the Faculty of Law. Thank you very much. And this ends our proceeding in the seminar. Thank you.